Hello and welcome to our first businessadvice.co.uk webinar. I'm joined today by legal expert David Walker, a regular contributor to the website and someone well versed in today's topic. This afternoon we'll be looking at how intellectual property can give your small business the competitive edge, something a number of company owners don't give enough attention to. The format will see David spend 20 minutes or so covering the nuts and bolts of IP protection, touching on trademarks, copyright, patents, and registered design. After that, I'll be asking David a few of my own questions, looking at some subject matter in more detail. Finally, it'll be your opportunity to have your own questions answered by David. During the course of the webinar, please submit any questions you may have regarding his presentation or your own business using the question submission option in your toolbar. We'll endeavour to answer as many as possible at the end. If we're not able to get to them in the time allotted, then we'll endeavour to have them answered by email in the next week or so. We have a few polls that would be grateful if you could fill out during the duration of the webinar. They're really important when it comes to shaping future content on businessadvice.co.uk. And then we also have a post-webinar survey that will really help shape future themes. If you'd like to share this webinar with your peer group afterwards, then fear not, a video will be sent out in a day's time. So before I hand it to David, thank you very much for joining us this afternoon for our first webinar, and I hope you find it really useful.
Thanks for that intro, Hunter. So, intellectual property is a subject that I find absolutely fascinating because you only need a little bit of knowledge or a slight tweak to your current strategies and your business can be absolutely transformed. And what I want to make clear right from the start now is what I'm going to tell you isn't going to need you needing a team of lawyers and patent attorneys to actually put this into practice. Yes, there may be times when you need professional advice, but there's a lot of it which you can do yourself. And to me, this is really important because intellectual property law is here to help you protect your business. It's your reward for putting in the creativity and innovation and sort of building a successful business. And this should be available to everyone. So let's just think for a moment about what makes any business successful. Think about your own business, or think about other sort of big businesses, whether it be Virgin, Apple, Amazon, anything which you sort of care to think about. What makes them stand out, if you ask anybody, is things like their innovative products and services, they have a trusted brand, they have fantastic customer service, enthusiastic employees, or highly efficient systems. And the more a business can capitalize on these, the more successful it will be. So, how does intellectual property fit with this? Well, when you find your competitive advantage, whether it's solving a customer's problems, whether it's enhancing their lives in some way, whether it's saving them time, helping to have more fun, whatever it happens to be, you naturally want to protect it. And that's what intellectual property law is for. As I said, it's your reward for being creative, for developing new technology, and for growing a successful business. So you need to know how to use this law to your advantage. So what I'm going to give you now is an overview of the types of intellectual property that you're likely to find in your business, and then we'll see how you can use it to give you a competitive advantage. What I find when I'm talking to clients is that most people are familiar with the names of the different forms of intellectual property. They've heard terms like copyright, patent, trademarks, those sorts of things. But what they don't realize is that the intellectual property gives a very specific protection with the different types that there is. So what we're going to look at now is just a quick run through each of the different types of intellectual property and see where they fit within your business. So, if we start with patents, patents protect how things work. And most people naturally think of patents, they'd be thinking about the big tech companies where they've got dedicated research and development departments and they might be protecting thousands of patents a year. But it's not just a case that it's something available to the big companies. Any small business can register patents too. And I've done a lot of work with small business owners who have developed a new technology. I've worked with university commercialization departments, and one in particular where their product design students, as part of their final year project, if they develop something new, they can actually protect it as by way of a patent. And one of my good friends has got a great example of this. For his final year project, he developed a bicycle pump. It was designed in such a way that the pump actually fitted within the seat post of the bike, and then he was able to obtain a patent on that, and then he was able to license it out to a bike manufacturer, and he had a great business based entirely around that patent. So you've got sort of the patents for new technology, new inventions, but the application is much wider than that. In the right circumstances, software and even methods of doing business can all be protected by way of a patent. And if you can get a patent, that patent will give you exclusivity to use that invention for up to 20 years. However, there is a downside with patents, and that is that you must show the world how it works. So in exchange for getting this exclusivity in your patent application, you tell everyone exactly what it is, how it works, and it's just sort of making new technology available to everyone. But they can't use it, otherwise they'd be infringing your rights. So it's a bit of a, you've got to weigh up the pros and cons of that. Do you get the exclusivity but show everyone how it works? Or do you sort of decide, no, I'm not going to register it, and as long as your product isn't something which is easy to reverse engineer, then you can have that exclusivity for as long as you like, for as long as nobody discovers how it works. A good example of a patent is Amazon's one-click ordering process. And again, this is an example of how once the 20 years has passed, the patent expires, and now it's free for anyone to use. So if you sell anything online, you can be using the same technology Amazon had without any fear that they may come after you with any form of legal action. Unfortunately, not all inventions are protectable. To be able to obtain a patent, there are 3 criteria which you must fulfill. First, the technology must be new. This means it mustn't have been disclosed anywhere before. So you can't have written about it in a trade journal. You can't have already produced a product incorporating the technology. You can't have displayed it anywhere. Those sorts of things mean that it's already in the public domain and you can't then get a patent. Next, there must be an inventive step. This means that your technology must take sort of technology overall a significant step forward. It mustn't be just an obvious development of existing technology. And then it must have some sort of commercial application. And basically this means that you must be able to sell it or sell a product which incorporates your patent. If you can do that, if it fulfills all those criteria, then absolutely you can apply for a patent. But in many cases, you have to make a commercial decision as to whether or not you're going to go down that route, because applying for a patent can be expensive. There's fees to pay to the Intellectual Property Office, and probably in most cases you'll want the help of a patent attorney to help you draft it to give you the maximum protection. And in the simplest cases, you're probably looking that it's going to cost you round about £2,000 to get your application through, and then for more complicated patents, it's obviously going to be more. Another issue with patents is that they're geographical. So you have to choose the territories, the countries where you want protection. And then if your technology infringes outside those, you've not got no grounds. So you can only sort of protect it where you've got it registered. And obviously if you're selling internationally, then if you're protecting in a lot of territories, again, that can increase the costs. But of course, we don't just buy things based on how they work. We also make purchasing decisions based on how things look. And you can protect the way a product looks by way of a registered design. And in my opinion, registered designs are probably some of the most underutilized forms of intellectual property, because they're actually much cheaper to register than a patent, and they give you good protection. You get 25 years protection, and you can protect either the whole of a product or just parts of it. But if you are just protecting parts of it, then there's a requirement that the part you're protecting must be on view in normal use. So it's no good for protecting sort of the internal workings of a product. A good example of a registered design is a trunkie, something which any of us have got kids, I certainly have. We'll all be familiar with the trunkies. This was a great design, but unfortunately there's been various court cases around it, and these cases have highlighted the fact that you need to be really careful with the images that you actually file. If the design is infringed, then what the case will look at, they'll go back to the pictures which you filed with your application rather than the product which has been made from them. So it's important when you're making your application just to think about what it is you're actually protecting, look at the views, look at the way the images are presented, that sort of thing. Just like a patent, not everything is registerable. If you want to register a design, then there are 3 criteria to fulfill. First of all, your design must be original. It must have some sort of individual character, so it must be distinctive, and it mustn't be excluded from protection. So things which would be excluded from protection are things like surface designs. The actual design mustn't be functional, and so what you're looking to protect is sort of the aesthetics of the design, and the design mustn't be dictated by the way the various parts fit together. And as I said, obtaining a registered design can be much cheaper than a patent. You can get good protection by way of registered designs for a few £100 rather than a few £1,000s. And again, like patents, you need to choose your territories to make sure that the countries where you're actually selling your products are all covered. Obviously, if you can protect how your product works by way of a patent and how it looks, then obviously you're onto a winner. But for a lot of businesses, just going for the registered design is a really good option. And understanding that these sorts of rights are available means you can make some slight tweaks to your design process. As you're actually looking to design a new product, if you start thinking in advance about, okay, I might want to register a design, that can influence some of your decisions, so you can make something distinctive about it. Don't just focus on how it works, focus on how it looks as well, and then you can get some protection for it. So, patents and registered designs obviously going to be most relevant to businesses which are selling products. But there's also a lot of protection you can get if you're providing services too. So the next form of intellectual property we're going to look at is trademarks. If you think about whether it's products, services, whatever, we buy from people we know, like, and trust. And how do we know whether we know, like, or trust someone? We recognize their brand. And this is what trademarks do. They protect their brands. And again, it's probably a misconception of a lot of business owners that the only things you can protect are things like names and logos. But the protection you can get from a trademark is actually much, much wider than that. As long as something can be represented graphically, you can protect things like slogans, you can protect packaging, so think Coca-Cola bottles, they're registered as a trademark, and even colours. So green has been protected for BP service stations. Unlike patents and registered designs where the protection can run out, with a trademark, the protection can potentially last forever. You've just got to renew it every 10 years. However, a downside of this is that once a trademark has been registered, it's set in stone. So if you rebrand, if things change, then you will need to register a new trademark for them. And in terms of examples, think of any famous brand, think of any brand, and it's probably protected by way of a trademark. I've got some examples here: Amazon, Google, Apple, Facebook. Each one of these has got any number of trademarks registered for all their different elements of their brand. So you can get a good level of protection for your brand too. Obtaining a trademark is relatively straightforward, but again, not everything can be protected by way of a trademark. There's 3 criteria which you need to fulfill. First one we've already mentioned, and that is your trademark must be capable of being represented graphically. So effectively, you've got to be able to put it down on a form. It needs to be distinctive, not descriptive of what your products do or what your services are for, and not excluded from protection. So there's certain things like national emblems, flags, things like that. You can't give any indication of sort of geographic origin of your products or services. If you do, then it won't be protected. Then you make your application, file your application with the Intellectual Property Office, and in doing so, you need to choose the classes in which you're going to register. So there's 45 different classes covering all types of goods and services which you can imagine, and in most cases, you're probably only going to need to register in 1 or 2 classes. If you have a broad range of products and services, maybe a few more, but in most cases 1 or 2 classes are fine. And again, trademarks are territorial, so think about where you're trading, what countries you need protection in, and then again, fees to pay. Relatively modest, but they can get a little expensive. UK Intellectual Property Office, to register 1 trademark in 1 class is £200. And then for each additional class is another £50. If you register 2 trademarks, so say a name and a logo, you have to pay fees for both. So that's when it can start adding up. Also, if you're registering in numerous countries, then obviously you can run up the fees quite quickly with that. The final form of intellectual property which I want to look at is copyright. And most people, when they think of copyright, think about sort of art, music, literature. But if you put that into a business context, a form of artwork could be surface design of a product. Music could be a jingle which you use in your advertising, and literature, there's any number of examples. It could be blog posts, it could be your training materials, even software can be classed as a work of literature. And unlike the other forms, the patents, trademarks, registered designs, copyright protection is automatic. As soon as you create the work, as long as it's original, then you'll get protection for it. But the downside is that there's no monopoly. It doesn't give you any sort of exclusivity like the other forms of intellectual property. So if somebody comes up with something very similar to yours, if they've done it completely independently, there's not a lot you can do to protect them. And there's a really helpful trick which I want to sort of explain now, which most business owners sort of miss out on. And so one of the things people often tell me is that one of their key assets in their business is their staff and the knowledge and experience which they have. And if these key members of staff leave, they take all that knowledge and experience with them, and it can leave a bit of a hole in your business. But if you take the time to capture all that knowledge and experience, if you get them to write blogs, if you get them to document the processes which they go through, all of these things become an asset of the company. And then after they leave, you can continue to use them. You can use it to train up new members of staff. You can then sort of add to it as you go along, and your business can have a good level of protection from sort of the potential loss of somebody leaving. Now, you're not going to get exclusivity to that knowledge and experience. They're still free to take it with them as long as they don't breach any of their restrictive covenants in their employment contract, but at least you've got something which you can then build on and hopefully fill some of the gaps of them leaving. Just very quickly, there are other forms of intellectual property which you might come across, but unfortunately we don't have time to go through all of these today. There's things like unregistered designs if you can't get to the registered design, unregistered trademarks, database rights, and trade secrets quite often confidential information and trade secrets are put in with intellectual property, and they can provide some useful protection as well. But I guess the big question is, which you're all sort of logged on to hear about now, is how do you use these intellectual property rights to give your business a competitive edge? And the big thing I like to do is to think of your intellectual property as an asset, just like you think of any sort of physical asset. And when you start thinking of it in the same terms of a physical asset, you then start seeing all the possible opportunities there are to use it. For example, you can use it to create and sell your own products and services. Things like the patents, you can make products based on that technology. You can use it to protect these products from counterfeiting. If someone's producing counterfeit products, then you can clamp down on that. You can stop them doing it. You can restrict the activities of your competitors by having sort of broad protection around your technology. If they're moving too close to what you're doing, again, you can stop them. If you're not in a position to use the intellectual property to produce your own products and services, then you could license that IP to someone else. Like I said with my friend, it's a case of he had developed a piece of technology, but coming out of university, he had absolutely no ability to manufacture these things and go out and sell them himself, but he could license it to a bike manufacturer who could, and then he could receive royalty income from that. Rather than licensing, then there's the opportunity to sell it. Again, it's an asset. Some companies, they'd be prepared to buy a patent and then it's theirs, which they can go and do. Rather than getting ongoing income, you'll get a lump sum from it. And also, using your intellectual property, it can give your marketing added credibility. Who remembers this? The advert by Audi, talking about how many patents NASA has filed compared to how many they filed in developing the A6. An advert like this leaves you in absolutely no doubt as to how important intellectual property is to a company like Audi. So, just like any other assets, if you don't protect your intellectual property, it can be lost or stolen. So, what should you be doing to protect them? I think the first thing you need to do, you need to be vigilant. You need to be always on the lookout for possible infringing products, look out for what other people are doing, set up Google alerts for any of the names or phrases or slogans which you're using, then you'll be alerted to anyone else using them. Carry out regular searches. I'm forever on eBay and Amazon looking out for certain my clients' products where we know that they get copied quite regularly. When we find something being sold, we can then look to take action as soon as we can. If you can't do this yourself, then there are some professional watching services where you can sign up and pay a subscription. Then they keep an eye out for you, and if they find anything which they're slightly concerned about, they'll contact you and say, what do you want to do about this? But I think that the big one for all of us, particularly in the, to do with sort of protecting your brands and your trademarks, is the dangers which come with pay-per-click advertising these days. What I'm finding is that it's very rare now for someone to copy someone's branding to try and sell products under a same or similar brand, because most people want to create their own identity. But what they are doing is using a competitor's names, their product names, their trademarks, those sorts of things, as keywords in their pay-per-click advertising. And what they're trying to do is, when people are searching for those things, divert traffic away from you and to their websites instead. If you've got your brand protected as a trademark, this is quick and easy to clamp down on. However, if you haven't got things protected, then it can be much, much harder. So it's, again, it's a real strong thing. I really recommend that people spend some time to protect their brands just purely on this, because I see this is going to be a growing problem in the future. And then when you find any sort of hint of something being used without your permission, take action. The longer you leave it before taking action, then the more potential damage is going to be done. So don't wait. Clamp down on it, take advice if you need to, but do take action. So I've sort of rattled through a lot of information now, and you might be wondering, where do you start? And I think probably the best place to start is understanding what intellectual property you have now. So carry out an audit. What names do you regularly use for your business, for your products, for your services? What domain names have you got registered? Again, a little hint here, something which I come across all too often. If you've got domain names, make sure that they're registered in the name of your business. Don't have the problem which one of my clients had, is they're all registered in the name of his IT manager. When he left, they had any number of problems where he went and suddenly shut down all of their websites. Understand what IP your competitors have. You can search trademarks, registered designs, patents, those sorts of things. Have a good idea of what they're doing. This will give you an idea of the sorts of areas they're moving into, potentially the areas which they've missed, and that will allow you to move in and gain an advantage there. And then understand what you want to achieve. Are you going to use this intellectual property to create your own products and services? Are you going to just develop it and then license it out to somebody else? Any number of ways which you can sort of make the most of this for your own benefit. And then once you've sort of good idea of what IP you've got, where do you need more protection? Do you need to go back and start registering some trademarks? Unfortunately, you can't probably retrospectively protect the technology if it's already out there. It's not going to be new anymore, so you won't get the patents. But what you might find is that if you've got some existing technology, if it's going under sort of constant cycles of development, then you might be able to get patents on something new. And obviously, there is going to be a cost of this, so think about what your budget's going to be, think about what your priorities are, and put some money aside to really look at your IP, because if you get this right, this can make a huge difference to your business. And obviously, if you're stuck on any of this, then please feel free to ask. There's people like me who are here to help, and I'd be delighted to help with any questions you've got. So that's basically what I wanted to do. Hopefully we've got some questions come in. There's some people who've asked me questions in advance, so we can cover those, but Hunter, back to you.
Thank you very much, David. Lots of food for thought there. I'm going to ask David a few of my own questions right now. In the meantime, though, I'm going to launch our polls, and if you could let us know, your insights on this, and we'll get back to those at the end. As David also mentioned, please do submit any questions you have off the back of his slide presentation there. And once we've got through my questions, we'll come back to the questions that you may have. So I'm going to kick off by asking quite a simple one. Why is it important to be aware of what trademark law looks like before you begin development of something that you'll one day, in theory, want protection for?
Okay, so yeah, this is, so it comes about an issue I regularly have with clients. They will come to me quite often when they've been through the whole sort of branding exercise. They've come up with a name, logo, all the brand they want to, and say, David, can you register this as a trademark, please? And quite often I'll look at it and go, oh, sorry, it doesn't actually fit with the criteria of being a trademark. And unfortunately, if people had sort of come to me earlier on, then we could have sort of looked at sort of the process of what it takes to register a trademark, and that could be thought of. So if you come to me too late, then you could find that you've got some wasted time, effort, and money there, and have to go back through the branding exercise. So I always like to start with the end in mind. If people know that they're going to trademark something, if you're aware of sort of the requirements of what it takes to be registered as a trademark, you can build that into the process of sort of creating a trademark in the first place.
Thank you very much. So I think after each question I asked David, we're going to come back to the results of a poll. So I asked you all to what extent you had considered the value of your company's IP prior to this webinar. So results are in: 15% said not at all, 38% a little, 26% moderate amount, and 20% in some detail. So by and large, most people hovering around the a little to moderate amount. So hopefully this is kind of giving you some insights into how you take that to the next stage. So next poll before I get on to the next question. What has held you back from better protecting your IP? So let us know that, and I'll ask David my next one. So what can people do themselves, and what do they need a lawyer for, or expert advice?
Theoretically, you could do everything yourself. There's loads of free advice out there. You can go to the Intellectual Property Office website, and they will help you through all the registration process. But what I tend to find is that to get the best protection, things like patents is where you'd probably spend the money on getting a patent attorney to draft the application for you, because it's something where you want the protection as broad as possible, but you don't want to go too far that you're either going to step on someone else's toes, or it's going to be so broad that you're not actually using all of it. So that's where professional advice can really, really help. Registered designs, I've got clients who quite happily register them themselves. If it's the first time doing it, it might be best to take some professional advice just for the first time, but then after that it is pretty simple, so you can do it. And I find that with a bit of help, most people can register trademarks themselves. The process is relatively straightforward. There's a bit of searching involved, making sure that you're going to be registering the right classes, those sorts of things. But in general, it's something where everyone can do. And then, so that's protecting. And then, for the most part, just being vigilant and keeping on top of your IP. As I said before, setting up your Google alerts, searching Amazon, eBay, places like that, just being vigilant as to how your IP is potentially being used. Most people don't need any watching services. You can save yourself a lot of fees by doing those things yourself, or getting other members of staff to do it for you. Just set them up, make it a process where once a week, once a month, whatever it is, they just do some regular searches to find out what they need to be checking.
Thank you, David. So, results from our second poll. I asked, what has held you back from better protecting your IP? 14% of you say not enough time, 56% worried about costs, so over half there, 28% can't access the right support and advice, and 31% don't know where to start. So hopefully through this afternoon we've helped the 31% of you out a little bit with don't know where to start, and maybe also those who can't access the right support and advice, you now know where you can start to go look. Final poll before I ask a few more questions. What are you most interested in protecting? So we've got company brand identity, which means trademark, software development, which means copyright, products, how it works, patent, and products, how it looks, registered design. David, under what circumstances are you seeing mistakes in this area most often?
I think this is something which I've already sort of touched on, and that people don't take advice soon enough. They're missing out on a lot of protection because they in a lot of cases don't know what protections are out there. I had one case. I was actually working for a large tech company, and one of their employees had an idea for a new piece of technology. Great idea. Unfortunately, didn't sort of follow proper procedures. Thought he would gain himself some brownie points, went and developed it, actually shared it with some friends outside the organisation and worked on a bit more, brought it back to his line manager as a fully developed product and said, wow, look at this is going to make us a fortune. Unfortunately not, because he'd made it public, they were unable to get a patent. Rather than a pat on the back, it was actually a disciplinary matter. So that was a huge, huge issue for that company. But in sort of general terms, I think, especially like on the what I mentioned with the trademarking, people getting to the end of the sort of the brand creation process and then finding out that they can't trademark it, then needing to sort of go back and redo things. Developing a product like I say, missing out on the potential of a registered design because they didn't know that they could protect how it looked, and they were solely focused on making it function as well as it could. So I think hopefully, having sort of listened to this webinar and other bits and pieces, if you're aware of these things, you can prevent a lot of mistakes by just being aware of what rights you've got and then making the most of them.
Fantastic. Okay, so results of our final poll before we start answering some listener questions. I asked, what are you most interested in protecting? Perhaps unsurprisingly, 55% want protection for company brand identity, followed by 9% software development, 18% products how it works, and 15% products how it looks.
I think, yeah, that sort of really coincides with the work I do as a solicitor, that a lot of people, most businesses, they all need to protect their brand, and the patents, the registered designs are a lot more specialized. But I think also, again, the registered design is lower because people have less awareness of it. So hopefully if we can bring a bit of attention to registered designs, that will go up a bit and people will be sort of more focused on how things look as well.
Fantastic. Okay, so we'll move on to first question from one of our listeners. If you have a company name and logo, can you register just the company name or even just the unique part of it?
Absolutely. As long as it fulfills those criteria, then, which I mentioned before, so it's got to be able to be represented graphically for a name, logo, something like that. That's absolutely no problem at all. As long as it's distinctive, not descriptive of what you're doing. And as long as no one's got in there first, then absolutely you can register it as a trademark. And that sort of also links in with a question which I had in before the webinar started. Is a guy said he was a sole trader and he traded as with a business name rather than his own personal name, and he was asking whether he should also form a dormant limited company just to protect that name. And again, sort of answering his question is protecting, just registering a company isn't really going to protect the name. Trademarks are what you need to do to protect the name, but they must fulfill those 3 criteria. He didn't tell me what the name was, so I can't say, yes, that's registerable or not, but that's the way to go. You don't have to register the whole thing. You can pick and choose bits and pieces of what you do register, but you're only going to get protection on the bits which you have registered.
Okay. This is quite a niche one, but maybe you can kind of broaden it out. Everything I do as a chartered architect is intellectual property, but which category?
Probably most of what you're going to be doing as an architect and producing drawings is going to be copyright. I would say that's almost entirely what you're doing. Possibly, depending on what you design, there may be the possibility of a registered design in there. We'd need to look at that, but yeah, the majority of what you're going to do is going to be intellectual property.
Okay.
Sorry, copyright.
Okay. Just a quick note, we'll be making David's contact details available in the webinar, so if we're answering a question, you'd like a little bit more detail on it, or you don't have something you want to ask right now, you will be able to get in contact with him. Another one, what about shared IP when working for a client, using their logo, brand style, and layout, including typefaces, but our design concept and artwork? Who owns what?
The basic position is that if you're using their logos and things, their own branding, then they own that, and they're giving you permission to use it. Anything which you then create for them, which incorporates that, you'll own. However, what most people do is in their terms and conditions will say who's going to own it after that. So what the standard position is that once the client's paid for it, then generally it all gets assigned over to the client. But there's no reason why you can't hang on to it. You wouldn't be able to sort of claim any sort of ownership to their name, their logo, those bits and pieces. But if you've done sort of some layouts of adverts or other bits and pieces, then you own that because you've created it.
Okay. If you can prove prior rights when someone else has applied or attempted to patent something you've already done, could you then retrospectively apply for a patent? In this case, the idea was considered rather generic.
Any sort of attempt to retrospectively apply for a patent, you're not going to get it because it's not going to be new. However, what you might be able to do is challenge the validity of their patent, saying that it wasn't new because you had some prior art out there. If you can get their patent overturned, then neither of you got a patent, and at least you've then got freedom to go and trade as well and compete with one another.
Okay. Another quite niche one here. I've designed a universal bracket to hang doors in the retail sector. How can I protect the concept? I'm currently having a prototype made to destruct test. I don't think I can get a patent, but can I register the design and concept?
If it's distinctive in the way it looks, then yeah, possibly you could get a registered design. If the design of it is very functional, then maybe not. But again, if you're still at the prototype stage, have a think about what you can do to try and make it more distinctive. What shapes can you add in? What can you do to make it? And then you can potentially get that registered. And again, one of the good things about a registered design is you do actually have a grace period. So if you've already produced this, you don't have to have registered it straight away. You've got a bit of time to get that registration in. But by all means, drop me a line with details of what the design is, and we can take a look at that for you.
Okay. If registering a patent in China, is it better to engage Chinese patent lawyers to act for you to give you a better chance of protecting your patent from copying rather than using a UK patent lawyer?
You need someone who knows what the law is over there, where they're going to do. A lot of the sort of the bigger patent attorneys, they've got international offices, so you could probably engage someone here with a local office. That's probably your best bet. Otherwise, yes, I'd probably go to China. But also, I'd sort of question also whether you need to register in China. And again, this is another question I had, but it was sort of registered design related. Somebody was looking to register a design, but their product was potentially easy to copy in the Far East, so they're wondering whether or not it was worth it. What you can do is sometimes accept that things are likely to get copied out in the Far East, but they can be infringed by somebody else selling them or importing them. So what we've done in certain cases, like accept that a product's going to be copied all the time in China. As soon as it lands in the EU, where we've got good protection, we'll then take action against the people who've imported it. So just think about the commercial strategy around protecting it in China, whether you're actually going to, once you've got that protection, enforce it out there and take steps to protect the patent. So there's a lot to think about there, but yeah, look at some of the bigger patent attorneys, see if they've got a local office, and they'll be able to help advise you on all those issues too.
Okay. A couple more questions before we let you all go back to your busy lives. And as I said at the top, we will make sure that David will get back to you in some fashion if we don't manage to get onto your question in this session. So don't worry, there will be something that comes back to you. I have a training program developed which I believe to be unique. I want to expand into book form for sales. Is it copyright that protects the name and the process?
The name is potentially protected by a trademark, but the materials, what you've written, is going to be copyright. However, again, depending on how you structured your training, what a lot of people are doing, they have sort of a framework which they teach from, and perhaps that framework might be an acronym for something. So potentially you could protect that acronym as a trademark as well. And again, that gives you an added layer of protection. But generally you're looking at sort of copyright for the actual materials and trademarks for the name.
Okay, let's see if we have one more here. This is another architecture one. How much protection does copyright give me as an architect producing designs that are very similar but not quite the same?
The copyright gives you good protection, but what you have to prove is that your designs have actually been copied. So if somebody has come up with something similar but not the same, if they've done that completely independently of you, then you've probably not got a lot of protection there. So copyright's not the strongest form of protection. You actually have to prove that someone's copied you to have any sort of claim against them.
Okay, before we wrap up, The China patent question person has come back to said, the patent will already have been registered in UK and various other countries, but we fear being toothless in China by registering from the UK.
Okay, so yeah, just speak to your patent attorney, whoever sort of helped you with the other patents, see if you can get some new protection out there. That may be possible. But again, what I've tended to do is just accept that infringements happen in China, then take action when they land in a territory where you've got good protection. I found that's generally the easier, more practical route to take. But yeah, certainly speak to somebody and see whether there is better protection you can get.
Okay. I'm afraid that's all we've got time for this afternoon, but thank you everyone for joining us. David, I'm going to quickly let you tell everyone listening how they can get in contact with you if they do have a burning question, whether they want to use your services, get some expert advice. What's the best way?
Drop me an email, dwalker, that's DWALKER, at gridlaw, GRIDLAW.com. And I'd love to hear from you.
Fantastic. Thank you very much to David today for his brilliant presentation and rather astute off-the-cuff question answering with some very, very niche questions there from some of our listeners. So thank you very much for that.
Brilliant. Thanks, Hunter. Pleasure.
From a business advice point of view, thank you very much for joining us for this first webinar. I hope you found it very useful. As I mentioned at the top, we do have a short, very, very short survey going out afterwards. It'd be great if you could let us know how you felt it's gone, what value you got out of it, and also looking for a bit of direction on what kind of themes we look to cover in future webinars. We want to keep providing you with really, really insightful advice-based content, whether it's online on businessadvice.co.uk or through mediums like this. So please do let us know, and we hope to welcome you back for future webinars in the not too distant future. So one more thank you to David. Thank you for joining us, and hope to see you all very soon. Thank you very much. Goodbye.
Thanks. Bye-bye.